at all, correct?
I did.
Okay, so despite this beating, there was no reason to go to the hospital, and none of those things showed up on videotape. You'd agree with that, would you not?
I don't agree with that.
Your
Okay.
Honor, objection.
What's the objection?
The objection is improper.
It's speculative for her to have to answer what's on the video that she didn't see.
Correct.
So, now, what liquor store did you go to?
I don't know the name of it.
Where was it?
Warren and Haverhill.
Warren and Haverhill. When you stopped at the liquor store, did you go in and do any shopping?
No, I didn't. I couldn't.
Did anybody else leave the vehicle?
Yes,
Who?
they both did.
They both left the car.
They did.
And of course, when they both left the car, that's when you got out and ran away because you were being held against your will, right?
No.
No, as a matter of fact, you stayed right there to allow the kidnappers to return, correct?
I did.
Okay, so they both go, they get out of the car, they walk into the liquor store, right?
No, they both didn't walk in the liquor store. One of them walked in the liquor store. The other one, sister had came in. She pulled up on the side and she went to her car with the gun. My sister.
So Maya's sister was out there with the guy.
Yeah, she was in the house. She was in the house when everything was happening.
Okay, so there's a third person that was there?
Yes, and they knew that.
Who's the third person?
Her name is Leah.
Her name is
I don't
Leah?
know her last name.
Okay, and so Leah was there also when this went down with the gun?
Yes.
Okay, you know, you made a statement after this was over, correct?
What statement?
You made a written statement?
Yes, I
Okay,
did.
and then you signed and affixed your name to that statement,
Yes, I
correct?
did.
Do you have any idea why this person Leah's name does not appear in that statement?
Because she wasn't the one that kidnapped me.
I see, so you
She was
said,
in there and they knew that that's in the statement. I
Okay.
told them that she was in
I
there.
got her. You're on
okay,
the record.
so you're telling me right now that Leah's name is in your written statement, is that
It
right?
should be, yes. I told the officer, the responding officer, what happened.
Okay. All right, so the sister pulls up at the liquor store. And this separate sister has a gun, right?
I never said the other sister had a gun. I said Maya had the gun.
Okay, so did Maya hand the gun to her sister at this
No,
point in
she
time?
took it and took it with her to the car.
Who took it?
Maya took it, she got out with it and took it to the car with her sister and she hit the cigarette that they were smoking while Tasha was in the store. And they both came back
Okay. So they both came back where?
to the car.
To the car.
Yes,
They get in the car?
yes.
Who's holding the gun at this point in time?
Maya,
Maya has the gun.
yes.
Does her sister have the gun?
No, I never said her sister had the gun.
I see. And so when they smoked this cigarette together, was Maya physically in this other vehicle?
Yes.
Okay, so she was in the passenger side of this vehicle, correct?
Yes.
Where is this vehicle in relationship to the Durango that you're riding in?
I don't know, it was a whole different car
Was it on your right or your left?
on my left.
On your left. How far over on your left?
I don't know.
Okay. And so were there any cars between your car and their car?
No,
No? Now, did you signal to anybody as you were up there at this liquor store?
nobody was up there, it was just us.
I'm-
No, I didn't.
Okay, now this is April the 11th, right?
Yes,
It's in the middle of the day, right?
yes,
I mean, it's like, what, noon, 1 o'clock?
yes.
Okay, and at noon or 1 o'clock, there was nobody up at this liquor store, is this right?
I don't know. I don't recall seeing anyone.
Okay. All right, so now, just so we're clear here, now, in the beginning, in terms of what takes place, had you been texting back and forth or calling the folks that came to your house earlier this day on the 11th of April?
No, they called me and it was never neither one of them.
They called you?
Someone, Maya's mom called me. I
Okay.
never talked to neither one of them,
Did
other
you,
defendants.
did you ever call or text them?
No,
That never happened?
not that day.
Okay. Did you call or text them asking them to pick you up?
Your Honor.
Why would I call and text somebody to call and pick me up? No,
When there's an objection, you gotta stop talking, okay? Because what you may say might not, should not be on the record, okay? So you hear an objection, just stop.
Your Honor, the objection is that counsel already asked the question when she had spoken to anyone and the witness stated.
Not that day, no.
So, now, the door to your house, did you let these folks in?
I opened the big door, yes, because I recognized it was Tasha at the door.
Okay, and you opened the door, didn't have anything to do with any text messages or communications with him that you had by phone earlier that day?
We didn't have any text message or phone by earlier that day.
Okay, and so you opened the door, and then what happened?
They came through.
Okay. You're standing there, right? Are you standing in the doorway now?
Right.
Okay. Of course, there's other people that are home in your neighborhood at this point in time, right?
Yes, and they saw everything.
They saw, who were the people that saw everything, man?
My neighbors across the street and the person that was in the basement heard everything while we were at the house.
Who are your neighbors across the street?
I don't know her name. This is my grandmother's neighbor.
Your grandmother's neighbor? And she stays across the street?
Yes,
What color's the house she lives in?
brown brick.
And she lives in a brown brick house?
Yes,
And you're saying this person saw everything?
yes.
Of course, you told.
It was her daughter, actually. She was a kid, a little kid.
It was her daughter?
Yes,
So it wasn't her, it was her daughter?
yes,
Okay, so it wasn't the lady, it was actually a little kid?
yes.
Okay. Do you have any idea what this child's name is?
No, I don't. They're not my neighbors or my grandmother.
Objection.
But this is, just so we're clear here,
This is objection.
witnesses to the res gestae, witnesses to the crime are certainly relevant, understanding who they are for future litigation purposes are certainly relevant question. So, you have no idea what this child's name is?
I do now.
Okay, and this is on April the 11th in the middle of the day, right?
Yes,
How old was this child, do you know?
I don't know.
How old does the child appear to be approximately?
I don't know.
Okay, I mean, just so we're clear, I mean, it's a school day, is it not?
It is.
Okay, and so April the 11th, during the middle of the day, which is a school day, this child is home and just happens to be out on the street, is that right?
I'm not her parent.
I didn't ask you if you were.
I don't know why she wasn't in school.
Where was this child that you say that she was in a position to make these observations?
She was in her house.
So she wasn't out in front of her house?
No,
She was in her house?
yes,
How do you know she saw?
because that's what they told me afterwards.
Who told you?
My grandmother's neighbor told me afterwards.
Hearsay.
It's the same. To be stricken from the record, it's hearsay.
Now, let's just be clear about something in terms of, I mean, in the last 10 years, have you been convicted of a crime of theft or moral dishonest?
I don't know if it's convicted, but I did have a
If
case.
it's not conviction, the answer is no.
No,
Well, we rephrase the question. Were you not convicted of a crime involving theft or moral dishonesty in the state of Ohio?
yes,
Okay. Man, if you were convicted of a crime involving theft or moral dishonesty in the state of Ohio, why did you tell me a moment ago that you were not convicted of a crime involving theft or moral dishonesty?
what does that have to do with what we're talking
Well,
about
it
today?
bears in your honesty, something the truth, they
You
need
have to
into
answer the
consideration.
question. Just answer the question to the best of your ability.
What did you, could you repeat the question?
Man, if you were convicted of a crime involving theft or moral dishonesty. in the
I
state-
wasn't
in the state of
convicted.
Ohio. Now, why did you say you were convicted a minute ago?
I didn't say that. I said I didn't know. I wasn't convicted. I had a case, but it wasn't, I didn't convict.
It didn't, there was not a conviction, is that what you're telling me?
No, I don't believe so. I really don't recall.
Why was there not a conviction?
I'm not sure.
Your Honor, I would object as to relevance as to the basis of the questioning.
Oh, it's very relevant as far as credibility. But I don't think it's quite clear as to whether it's a conviction.
The answer is both ways, I would agree. Okay. So, just so we can understand this for purposes of the record, whatever happened to this case down in Ohio? I mean, did you go to court?
Yes,
Did you continue to go to court as you were supposed to?
yes,
You did?
yes.
And you showed up in front of the judge, right? Right?
Yes.
And you were ultimately convicted, were you not? You said you were guilty, didn't you?
I don't recall.
Okay. There were multiple cases in Ohio, though, weren't there?
It was.
And there were all multiple cases for theft in Ohio, weren't they?
I don't recall. I don't think there were multiple cases of theft.
And this was down in the Dayton area, if I'm not mistaken, right?
You're not mistaken.
Okay. What was the county it was in?
I don't recall.
What was the city?
Dayton,
Dayton, Ohio. Okay. All So, now, let's just circle back here. The police showed up, right, ultimately when you were let go, right?
Yes,
Any idea? Were you there when the police came back and executed a search warrant, correct?
yes, I did not leave.
Okay, now, when the police showed up and they came in to see you, where was the gun?
I don't know.
Okay, any idea, ma'am? Okay,
I was worried about leaving. I wasn't worried about a gun.
I see. But you were scared of the gun, weren't you?
I sure was.
And being scared of the gun, I mean, you'd at least want to have
When the
some.
police arrived, I felt a sense of safety, so I wasn't worried about a gun at that moment.
Okay, but in the moments before, being concerned about your own safety, you want to know where that gun was,
No,
right?
I didn't want to know.
Right. Any idea, ma'am, would you agree with me when the police showed up and they came in, that there was no gun in the room that you were in?
No,
You say there was a gun there?
it was.
Okay. Any idea, ma'am, why the police didn't recover that gun?
You have to ask your clients that, not me. I
Okay.
don't know.
Any idea why when the search warrant was conducted immediately after they come in,
That's
there
a
was no
question for
gun?
you and your clients, not
This is a
me.
question for you, you're
It's
on
not
a witness
question for
stand.
me. I don't know.
It is a question, I object to the non-responsive nature of the question.
I said, I don't know.
Okay, enough. Both of you, enough. Only one person can talk at a time. Let the attorney ask the question, even though it may be argumentative, or you may not like the question, you have to let her finish the question, okay? The attorney you have to let her finish the question as well.
I would assume it would be an answer, not a question.
I'm sorry, yes, let her answer the question.
Ma'am, any idea where this gun that you said that was being held on you all this period of time? Any idea where that gun was when the police were there?
I don't know.
You have no idea.
No.
I mean, you knew the police were looking for that gun, correct?
Yes,
You know, they executed a search warrant immediately to find that gun, right?
it wasn't immediate,
You know, they secured that house.
not immediately.
They didn't.
They did not.
So they let people come in and out of the house?
Yes, her father was allowed in and out the house
He came in?
multiple times.
He came in and out of the house
Yes,
multiple times?
multiple times.
I see. And so you're telling us as we sit here that you have absolutely no idea what happened to that
No, I
night?
don't.
Now, as you're sitting at the liquor store, did you try and signal anybody to get help?
I didn't see anybody to get any help.
How about as you were driving down the street?
No, I didn't.
How about as you were being taken away to your neighbor across the street?
No, I didn't. It was a gun on me. I wasn't worried about signaling to anybody.
Okay, but the same gun that nobody can find was the one that was on you at that point, is that right?
Mm-hmm.
Is that a yes?
Yes,
Okay. All right. And so when the police originally got you out of that, did you recall being let out of this home by the police? Do you recall
Yes.
that? And do you recall interacting with the police and stating what had happened?
yes,
Do you remember telling the police that you come over there on your own free will and accord?
no, that's what the defendant asked me to say, but I didn't.
Okay. Which defendant was that asked?
Tasha asked me to say that, and
Did
I
she?
did not. Yes, she
Of course,
did.
that should be on the videotape likewise as well, shouldn't it?
It should if they really videotaped it.
Okay.
Objection, the witness has already stated that she does not have knowledge of the videotape, and the questions regarding the videotape, the witness would not be able to testify to.
Speculative?
With that, Your Honor, I have no further questions to witness.
Can you redirect?
Oh, yeah.
Okay, now you are all done. You keep her, she's free. She's free. There's no other way to do it.
Thank you.
Any other witnesses with people?
No further witnesses, Your Honor.
Any defense witnesses?
You're done, Your Honor, thank you.
Who is this? Nancy leaves out the courtroom, then you can get your motion provided.
I have to.
You know what, actually, Ms. Mincy, this is, she doesn't have to, the testimony, though, you can see.
No, I really, I want to go out there, my mom.
When you, in your argument, there are a couple extortion instructions, you specify which, instruction you're relying on.
Yeah. At this time, the people would move to bind over the defendant on all counts. That is count 1, kidnapping, count 2, home invasion of the first degree, count 3, extortion, count 4, unlawful imprisonment, count 5, felonious assault. In regard to the, I'm sorry, what count did you say that you wanted specifications on, Your Honor?
Count for extortion, so count 3.
In regard to count 3.
You can do it in your order. I just, when you get to count 3, just specify which instruction.
Okay. With respect to count 1, Your Honor, kidnapping, the people need to prove 2 elements by probable cause standard. The first is that the defendant knowingly restrained another person. Restrain means to restrict a person's movement or to confine a person so as to interfere with that person's liberty without that person's consent or without legal authority. Second element, when the defendants did so, they intended to one or more of the following: A, hold that person for ransom or reward. And I won't go any further on that through instruction, Your Honor, because here, first, both of the defendants, Ms. Rodman and Ms. Pace, first knowingly restrained the complainant, Ms. Mincy, when they ordered her in their vehicle, against her will, and took her from the home she was at, her grandmother's home, where they intentionally held Ms. Mincy in their vehicle and at the defendant's home. Second, the defendants both held Ms. Mincy at their house in exchange for money in this case, as we heard from Ms. Mincy. And third, well, lastly, on this, there's probable cause to find over on count 1. With respect to count 2, home invasion of the first degree, the people need to prove 5 elements in this case, First, that the defendant broke into a dwelling. The jury instructions provide that force must be used. Second, that the defendant entered the dwelling. And third, that when the defendants broke into and entered the dwelling, that they intended to commit an offense, or that when the defendants entered, was present in or was leaving the dwelling, they committed the offense in this case. Or when the defendants entered, was present in or was leaving the dwelling, either they were armed with a dangerous weapon or another person was lawfully present in the dwelling. And here, Your Honor, first, both defendants broke into the dwelling belonging to Miss Mincy's grandmother, which she stated she also lived there. They broke in by breaking the window of the home that Miss Mincy was in. Upon inquiry, Miss Mincy did open the door of the dwelling and inquired as to who was outside. Unbeknownst to her, both of the defendants were standing at the door, holding the gun, and demanded entrance. We did hear testimony from Miss Mincy that there was a gun held at her, and they ordered to come into the entrance. Second, the defendants did enter the home at that time, and they drew the gun Miss Mincy was testifying about in order to gain entry to that home. Third, when the defendants did break into the home, they intended to commit several crimes, including extortion, kidnapping, and felonious assault. And fourth and finally, when both of the defendants entered the home and were in the home, they were armed with the gun, which is undoubtedly a dangerous weapon. For those reasons, Your Honor, we believe that there is probable cause to bind over on count 2. In regard to count 3, extortion, the people are relying on jury instruction CJI 21.1. And for that, Your Honor, the people need to prove by probable cause 3 elements. First, that the defendants threatened to injure the complainant's property, or someone in the complainant's immediate family. Second, that the defendant made this statement while saying it, or by writing it down. Third, that the defendants made the threat willfully, without just cause or excuse, and with the intent to get money by doing it, or make the person threatened to do or to not do something against that person's will. Here, both of the defendants, as we heard from Ms. Mincy, stated at multiple times that they were going to kill Ms. Mincy if she did not comply with their commands. They stated this while they broke into her grandmother's house, which is where Ms. Mincy was residing at the time. And this threat was made with the intention of getting money from Ms. Mincy, which is certainly not just cause or excuse. Given the facts stated on the record, the people believe that there is probable cause to bind over as to count 3. In regard to count 4, unlawful imprisonment, the people need to prove 2 elements by probable cause standards. First, that the defendant knowingly restrained another person. Restraining is defined as to mean forcibly restrict a person or confine a person so as to interfere with that person's liberty without that person's consent or lawful authority. Second, that the defendant did so under one or more of the following circumstances. A, the person is restrained by means of a weapon or dangerous instrument. I won't go any further, Your Honor, on that jury instruction, because here, both of the defendants did in fact restrain Ms. Mincy, and they both had the intention to do so. They restrained her by putting her in their vehicle and held her to gunpoint at this time. The testimony provided that Ms. Maya was in the backseat of the vehicle and a gun was pointed at Ms. Mincy at this time, while defendant Latasha was driving the vehicle. Secondly, the defendants intended to restrain Ms. Mincy with a gun. They intentionally had the gun held to her at this time while they were in the vehicle and in the defendant's home. And for those reasons, the people believe that there is probable cause to bind over as to count 4. With regard to count 5, felonious assault, the people must prove by probable cause standard 4 elements. The first, that the defendant either attempted to commit a battery on the complainant or did an act that would cause a reasonable person to fear or apprehend an immediate battery. Second, that the defendants intended to either injure the complainant or to make the complainant reasonably fear an immediate battery. Third, that at the time, the defendants had the ability to commit a battery or appeared to have that ability. And fourth, that the defendants committed the assault with a dangerous weapon. Here, Your Honor, the defendants committed a battery on Ms. Mincy by holding a gun to her at the home, at her own home, her grandmother's home where she was residing. They also held a gun to her while they were in the vehicle where she was transported against her will. And they also held that gun to her while they were transported to the defendant's home. They were assaulted many times with the back of the gun, as we heard from Ms. Mincy. The defendants did intend to injure Ms. Mincy because they stated that they would kill her if she did not comply with their demands. The defendant, both of the defendants had the ability to do so with the gun, and they actually did hit Ms. Mincy with the gun, as I've stated. And lastly, the assault was committed with the gun, as I've stated. And Miss Mincy clearly stated that she was hit several times with a gun, which was held multiple times by each defendant while they were in her home. And for those reasons, the people believe there is probable cause to find over as to count 5.
You know, I understand what the threshold is, in terms of the different counts. And so we object,